Hi, Assalamualaikum. I am from Group 1 and my group consists of 4 members including me, INTAN MARISSA binti HAMDAN, SYAIDA QISTINA binti Muhammad SUHARDI, ALYAA QISTINA binti GHAZALI, and ZULAZLIN ELIA binti ZAMZURI. Now, we would like to present about contract of sale of goods. Question 1. Imran ordered 400 pieces of ceramic tiles from Tikar Sendirian Berhad. The company promised to supply 400 pieces of ceramic tiles within 2 weeks. The size of each tile is to be 2 by 2 feet. When the tiles were supplied, Imran found that only 60% of the tiles corresponded with the size mentioned in their agreement. Imran was very disappointed. Imran would like to know his right under the Sales of Goods Act 1957. Advise him. Issue. The issue is to determine whether Tikar Sendirian Berhad has breached the implied terms that goods must correspond with the descriptions.
So I will be explaining about the area of law that is applied in this case. The area of law that is relevant in this case is the contract of sale of goods. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price as in Section 4 Subsection 1 of the Sale of Goods Act 1957. Besides, a sale occurs when the ownership or property in goods passes to the buyer. There are elements of a contract of sale of goods to exist. The first element is goods to be transferred to the buyer. Secondly, when the seller transfers or agrees to transfer property in goods to the buyer. And lastly, price for the said transfer, money, as the consideration of a sale of goods as in Section 2 of the Sale of Goods Act 1957. Furthermore, there are also terms of contract of sale. They are classified by condition and warranty. But before that, I will be explaining about the definition of stipulation. Under Section 12, Subsection 1 of the Sale of Goods Act 1957, a stipulation in a contract of sale with reference to goods which are the subject thereof may be a condition or a warranty. Moving on is the definition of a condition. A condition is a stipulation essential to the main purpose of the contract, the breach of which gives rise to a right to treat the contract as repudiated as said in Section 12 Subsection 2 of the Sale of Goods Act 1957. The general rule stated a breach of condition entitles the innocent party to repudiate the contract. However, there are exceptions of general rule when the innocent party cannot repudiate the contract but can merely claim damages. First, where the buyer waives the condition. Secondly, where the buyer elects to treat the breach of contract as a breach of warranty and claim damages only. Next is where the contract of sale is not severable and the buyer has accepted the goods or part of. Therefore, the breach of any condition must be accepted as a breach of warranty unless otherwise provided in the contract. And lastly, where the contract is for the specific goods, the property in which has passed to the buyer, the breach of any condition must be accepted as breach of warranty unless otherwise provided in the contract. Last but not least, warranty. Under Section 12 Subsection 3 of the Sale of Goods Act 1957, a warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages, but not to a right to reject the goods and treat the contract as repudiated.
Next, I'll be explaining on implied term in the Sale of Goods Act 1957, specifically focused on Section 14 to 17 of the Act. So according to Section 4 Subsection 3 of the Sale of Goods Act 1957, whether a stipulation is considered a condition or a warranty depends on the construction of the contract in each case. Even if a term is labeled as a warranty in the contract, it may actually be treated as a condition by the court depending on the circumstances. So the Sale of Goods Act implies several stipulations in every contract for the sale of goods. However, it is important to note that these implied terms only apply when the parties have not excluded or modified them. Now, let's move on to the specific implied term as provided under Section 14 to 17 of the Act. Under Section 14 Subsection A, there is an implied condition on the part of the seller that in the case of a sale, the seller has the right to sell the goods. In the case of an agreement to sell, the seller will have the right to sell the goods at the time when the property is to pass to the buyer. This means that the buyer is entitled to receive goods from someone who has legal ownership or the right to transfer the title. In the case of Butterworth, versus Kingsway Motor Ltd 1954, the court held that the plaintiff had the right to repudiate the contract and claim for damages, as the seller did not have the legal title to the goods, and this case illustrates the importance of the seller's right to sell the goods. Moving on to Section 14, subsection B, this provision states that unless the circumstances of the contract indicate otherwise, there is an implied warranty that the buyer shall have and enjoy quiet possession of the good. This means that the buyer should be able to use and possess the goods without any disturbance from the seller or third parties. If the buyer's possession is disturbed, it constitutes a breach of this implied warranty. Next, goods free from encumbrance. Section 14, subsection C provides that there is an implied warranty that the goods shall be free from any charge or encumbrance in favor of any third party, unless such a charge or encumbrance was disclosed to the buyer before or at the time of the contract. This protects the buyer from unexpected third-party claims or liability related to the good. In the case of Stank versus Edwards 1975, the court held that the government's right to tax and seize the charge. Since the buyer was unaware of this at the time of purchase and had to pay the tax, he was allowed to claim the money back from the seller for breaching the implied warranty. Next, I'll be explaining on the topic of implied condition by description under Section 15 of the Sale of Goods Act 1957. Under this section, when goods are sold by description, there is an implied condition that the good must exactly match that description. This rule protects that the buyer and the seller's obligation is strict, meaning that even if the defect is hidden or unknown, it's still considered a breach. This section applies in two main situations. First, when the goods are unascertained, such as mail orders or catalog sales. Second, it also applies to specific goods, especially when the buyer has not seen the good before buying. So the example cases is Nagardas vs. Mitsui Bussan, where goods was the right quality but missing a trademark. The court said that the trademark was part of the description, so it was a breach. Another example of case is Grant vs. Australian Knitting Mills, where the buyer paid the item himself in a self-service store. Even then, it was still a sale by description because of the label, and he could take legal action when the product caused harm. Now, let's look at the two categories of when a breach of description may occur. The first category involves a minor discrepancy in the contract terms where the goods mostly correct but with small mismatch. An example is the case of Moore vs. Landor, where the contract was for 3,100 cases of fruit with 30 tins each. But some cases had only 24 tins, even though the total number of tins was correct. The court said that the buyer had the right to reject the goods because they didn't match the description. The second category is where goods are described in general terms, but the delivered goods clearly do not match that description. A good example is Varley vs. Wheat, where a machine was described as new last year and lightly used, but in reality it was very old and had been repaired. The court ruled that it was a breach of condition and the buyer could reject the machine. Next, implied condition by fitness for a particular purpose, which is governed by Section 16, subsection 1 of the Sale of Goods Act 1957. Let's begin with the general rule under this section. It states that in the contract for the sale of goods, there is no implied warranty or condition as to the quality of fitness for any particular purpose of the good. In simple terms, this means that the buyer cannot assume that the good will be suitable for a specific purpose unless a certain conditions are met. The law does not automatically protect the buyer unless the buyer clearly makes their purpose known to the seller. Next, implied condition measurable quality. Still under Section 16, Section 16 subsection 1b provides that where goods are bought by description from a seller who deals in goods of that description, there is an implied condition that the goods shall be of merchantable quality. This applies whether or not the seller is the manufacturer or producer of the goods. In the case of Wilson vs. Rickett, Cockerell & Co., 1954, the court held that the entire consignment was unmerchantable as it contained defects which made it unfit for burning. Therefore, the seller had breached the implied condition of merchantable quality. Finally, implied condition, sale by sample. Section 17 of the Sale of Goods Act 1957 deals with sale by sample. It states that a contract is considered a contract for a sale by sample where there is a term in contract either expressed or implied to that effect. This means that if a sample is provided before the sale, the buyer is entitled to expect that the bulk of the good will correspond in quality with the samples shown.
Next, I will proceed with the application. So in this case, there is an implied terms of the Sale of Goods Act, which is the implied condition that in a sale of goods by description, as stated in Section 15 of Sale of Goods Act 1957, where there is a contract for the sale of goods by description, there is an implied condition that the goods shall correspond with the description. So the seller is absolutely obligated to this action, and it is no defense that the defect in the goods is latent. As for this case, Imran was aware that 40% of the ceramic tiles he received did not correspond to the description of the contract, referring to the exception of general rule for breach of condition, which is whether the contract of sale is not severable and the buyer has accepted the goods or part thereof. The breach of any condition must be accepted as a breach of warranty unless otherwise provided in the contract. So, Imran is entitled to claim for damages of 40% of the ceramic tiles that did not correspond to the size mentioned in the agreement. This is because he already received 60% of the corresponding tiles, so he can only claim for the damages of the wrong ones. So, Imran can reject the damaged goods, repudiate the contract, and claim the price of purchase. Lastly, the conclusion. So to conclude, because Imran Berhad has breached the implied terms that goods correspond with descriptions.